Protected works of human ingenuity in the ethereal realm include patents, logos, copyrights, designs, and trade secrets. The European Union has several laws and rules to ensure the producers and inventors' rights are protected while encouraging creative output and economic development. To update and standardize copyright rules throughout the European Union member states, the EU approved the Copyright Directive in 2019. The purpose of the order is to address concerns about the appropriation of protected materials online, such as responsibility of hosting sites for content submitted by users and the appropriate compensation of authors. Therefore, to solve this question, in the first step discussed under Article 17 of the EU Directive with its general definition shall be discussed. In the next step, critically analyze whether it creates a balance the copyright holder and the freedom of expression and personal data protection. For the next step, the scholarly opinion shall seek to justify the argument, and case law will be given to substantiate the above discussion. In the last step, under suggestion, the context will be made under Article 17. The EU Directive on Copyright in the Digital Single Market includes crucial clause known as upload filter provision. Under Article 17, it mandates that hosting services put in place safeguards to stop users from uploading materials. In order to protect the intellectual property law intellectual property law without permission, and to guarantee that artists get paid fairly for their use of work. Moreover, to comply with Article 17, websites must either acquire permission from the rightful owners to host user upload content or implement effective and proportionate means to prevent such content from being shared. Many people are worried that this will compel platforms to use automatic content screening system, which have the potential to block valid materials and restrict freedom of online speech. However, it has been argued that enforcing Article 17 could impede creativity and restrict freedom of expression. In contrast, proponents argue that it is essential to guarantee that producers are paid equitably for their work. Under the M. Leisner refers to intellectual property he who published it himself widely on the European Union Copyright Directive, especially under Article 17. Leisner is worried that Article 17 will limit people's right to from free speech and open access to materials on the internet. He contends that people's ability to make and share caricatures, cartoons, any other form of arts contents may be hampered if content screening systems are used to conform with the rule. Moreover, Leisner, on the other hand, has recognized the need to guarantee artists are properly paid for their work in the digital era, has advocated for more complex approach to copyright legislation that strikes a compromise between the interests of creators, online platforms, and users. He has suggested alternatives that could accomplish the objectives of Article 17 without excessively restricting freedom of speech, such as volunteer licensing systems and tailored removal requests. According to Stamatodi, a leading authority on EU copyright law, Irene Stamatodi teaches that intellectual property law at the University of Sheffield in the United Kingdom. In particular, she has discussed Article 17 of the EU Copyright Directive in her writings, that she agreed with the Article 17's aims, which include guaranteeing artists receive adequate compensation for their digital output. However, she also pointed out that the dangers of the clause, such as the protect free speech and the possibility of overblocking valid material. Moreover, she also suggested that a complex method of enforcing Article 17 that balancing the needs of authors, online services, and end consumers. She has advocated for more openness and responsibility for those who employ content blocking systems, and the creation of other methods for dealing the copyright violations that do not stifle free speech. Under Article 17, Stamatodi's work indicates that complexity and nuance of discussion surrounding copyright law in the digital age, and under the case law, under the case law, which is YouTube LLC v Siando on 2021. From the facts of the case, the German Federal Court of Justice heard arguments in YouTube LLC versus Siando, which involved a disagreement over Siando, the owner of the file hosting service, uploaded responsibility for the copyright infringements by its user. YouTube filed the lawsuit claiming Siando allowed users to post and share movies that violated YouTube's property. YouTube claims Siando should be held responsible for the illegal material and told to take action to stop further violations. The head of the case, in its final ruling, the court found that Siando could be held responsible for copyright violation if it had not taken adequate steps to prevent illegal material from being posted and made into public. The court ruled that Siando had not done enough to stop the transfer of illegal material and give the company precise instructions on how to do so. The comments of the case is important because it sheds the light on the scope of internet networks responsibility under German copyright law. Even though the case specifically addressed Article 17 of the EU Copyright Directive, it may have ramifications for its application because it shows how important it is for online sites to avoid copyright violations by the users. Critical analysis of balancing copyright and freedom of expression shows that there's been much discussion about how to strike between a fair equilibrium between copyright protection and freedom of speech in Article 17 of the EU Copyright Directive. This clause aims to make hosting sites responsible for the content uploaded by the users that violate intellectual property laws. It mandates that such site needed to take precaution to prevent the transfer and distribution of such content. The intention of defending property holders is commendable, but there are worries that the execution of Article 17 will stifle free speech online to an unacceptable degree. Moreover, overblocking useful content, including user-generated content like caricatures, jokes, and comments, is significant issue with content screening algorithms used to conform with Article 17. Furthermore, this may encourage people to speak their minds and limit their participation in an internet debate. Concerns may also have been raised that smaller online sites may be disproportionately affected by Article 17, as they may need more means to install the required screening systems. Because of this, rivalry and new developments in the online network industry may need to be improved. However, supporters of Article 17 say it is essential in the digital era to guarantee artists get paid what they are worth. They claim that online services have reaped financial benefits from the users, from the violations of protected works, that they know now must stop this practice. For the suggestion, since its 2019 approval, the link tax cost of Article 17 of the EU Directive on the copyright in the digital single market has been the subject of heated debate. Some solutions to the problems voiced by interest parties are offered from my suggestion below, which is keeping in mind the need of content producers and consumers. We must strike a fair balance between protecting intellectual property and limiting user access to the content. One way to strike this equilibrium is to define fair use or legitimate use of protected content and provide explicit means for disputing content takedowns as described in Article 17. The next point is transparency and responsibility should be fostered to limit any unforeseen effects and stop any misuse of the file filter that could result from failing to execute Article 17's provisions. Possible measures to achieve this goal include mandating that platforms provide details about their filtering methods and allowing users to dispute the conclusions drawn by the filters. The next point is to effectively find and remove illegal materials. The platforms and the right holders should collaborate to create tools and solutions to do so in a way that does not violate the user's right to do so. We may need to create new licensing models that permit more versatile use of protected materials, or we may need to create more advanced screening systems that can more accurately differentiate between illegal and non-infringing content. The next point is, in order to mitigate the risk of upload filter impeding innovation and constraining rivalry, it is essential that measures encouraging competition and innovation must be incorporated into the execution of Article 17. It could take the shape of financial rewards for the startups to enter the market, or more accommodating license terms for smaller companies to take on bigger platforms. In conclusion, the discussion could result in a huge debates among the critics of Section 17 of the EU directive on copyrights. Some stakeholders and scholars favours this article and its policies, but simultaneously they criticize the overall limitations on data protection and copyrights holder. Therefore, there are some scholars quoted above with their academic opinion on this particular issue. Critical analysis of this section also been provided. However, in the end, suggestion to fortify Article 17 and its implementation have been given to make resilience to cope with freedom of expression, and at the same time how this article deal with the copyright holder. That's all from me. Thank you.